I will take a little post, like in my Facebook, I have like, I do a 400 character thing every morning. But I'm also putting in a URL to, like, if I'm doing a restaurant,
Right.
and that's gonna have their photo on it. Now, technically, I would think that I might be liable, but it is their website, and it's completely located to their website, even though I'm using them. So how does that fit in?
So you're talking about Facebook. When you do the URL, it puts a little image from the website,
Right.
but you're not putting the image into your Facebook post. It's Facebook that's putting the image in because you're doing the URL.
Technically, yes,
Okay.
but I'm still putting it in there.
It's winding
putting-
up in there.
It's on there because Facebook is drawing it from their website, but you are not taking the photo and putting it
Right.
on Facebook.
Well, you have the option to share the link.
Right.
And I think that's when it,
Right, and Facebook is a little bit different than posting something on your website.
Okay.
If you took it on your website and you put a URL on your website and you took images from that URL and you put them on your website also, that could end up being copyright infringement because you are taking images from somebody else's website and putting them on your site without permission.
Okay.
There are some kind of instances where you could use images, and we'll talk about that a little later, but for the most part, if you just take an image from somebody's website, you put it on your site, even if it's with the URL, that is copyright infringement. Giving credit to the author is not enough to get you around copyright infringement. You have to get written permission, or you can in some cases get email permission, because a lot of times people are looking at emails now as the same thing as getting a written document that says, I give you permission to post this. So you get an image, you put it on your site with the URL. That's copyright infringement. Facebook, how they're doing it is they're just pulling it in, but I'm not exactly sure how they're getting away with putting the image on there, but it's Facebook.
I think it's because I've made it available for Facebook to do it. So if I do it in an RSS or I do it and I post it on my website and I say share it.
Well, except now Facebook will also let me, if I put in a post to something like CNN and I do the share, I put it in, so I say CNN has had this great article, here's the link to it, they'll put an image on there without me sharing it. So they're doing this, and I think it's because they're just using the image to do it.
Reference.
Yeah, they're referencing it, and I'm still not exactly sure how they're doing it, but it's more of a reference. And it's because they're also trying to make themselves into another Google where they're a search, so they're doing it under search terms that they're compiling things.
So that's a gray area then.
Yes. Most of everything online is still kind of a gray area.
It goes to
Yeah.
the expanded liberties that comes with all of this new territory that you mentioned, I'm sure.
And I'm sorry, I missed it. Did you say that you need to get written permission, or is an email?
An email is usually sufficient. The one thing that you need to make sure of is if you go to a website and you find a picture or you find a blog post or you find content that you really like on that website, you need to use your best judgment to make sure that whoever's website it is probably the true author of it. If you come to my website and I have Britney Spears' Baby Hit Me One More Time playing on the website, and you email me and you
I saw
say,
that at your site.
I know. See, I'm a really hip happening lawyer. But if you come to my website and you see that on there, and you email me for permission to be able to put it onto your website, it's pretty obvious that I probably don't have the rights in that song, and I can't give the rights to you if I don't have the rights on it. But if you come to my website and you see a post that I've done, and you email me and say, hey, I really like this post, can I use it? And I email you back and I say, sure, it's fine that you use it, here's the terms. In most cases, you could say on your blog, hey, I really like this blog post done by Jane Doe. Here's a link to it, you should go and read it.
Well, and I don't mean to keep talking about it. There's a lot of blogs, especially Gawker Media does this, where and I do it too, where, I want to create a blog post, I read an article that's interesting, and I say, here's my take on it, sort of an artistic license thing, which I know is, I don't mind about that, but they'll just, say, this is what was interesting about the article, here's the link.
Now that falls under fair use. With copyright, so you have a right in everything that you create. You have a copyright in what you create. There's a couple of different ways that I as an individual can end up using that copyrighted image or that copyrighted material. I can try to buy it from you. I can get a license from you. So I can say I would kind of like I did with the Missouri Paralegal Association. I granted them a license to use it in this term, or if you go to Facebook, you're granting them a license. The other way is under fair use. And fair use is a whole nother discussion in itself, but when you're providing commentary, parody, in those cases, you can use bits and pieces from the article or from the newsletter, or from the article or from the photo, or different things to say, this is my take on what the, and so you're falling under commentary, which in most cases, you do have to look at how much of the original article are you using and how much of it's really commentary. You can't post a 400-word blog post and at the end say, I really like this. That's not commentary. But you could say, you know, here's 3 sentences from this blog post. Here's my take on it. I disagree with it because of this. I disagree with it because of this. I agree because of this. I agree because of this. Here's the next 3 sentences. So it depends. You have to kind of weigh how much is commentary and how much is really reposting.
So what we did is we created an RSS feed manager where our clients that want to generate content, they can put in RSS feeds and then pull in a river of news. Then they can select which ones they want to comment on their website, and then they write what they want to write, but at the bottom it says, you know, this was from this was from this, and here was their RSS feed that they've shared, and that gives you a way of generating a lot of content without you having to be the originator necessarily, but most of it's your comments about what somebody else wrote. Yeah.
You said that we own the copyright for something that we create. Do we have to label that creation with a copyright trademark? Such as, it used to be you had to use a Circle C, copyright, your company name, and then the date.
You should put that on your things. You should.
Now, so if I've got my website and I've got my own logo,
Right.
do I need to copyright my logo there, or can I do it at the bottom of the page?
Logos are a little bit different. Logos fall under, in some cases, copyright. They usually fall under trademark,
Okay.
which is a different thing. You have 3 different types, well, you have 4 different types of intellectual property rights. You have copyrights. You have trademarks. This is going to be your slogans, your logos, in some instances, you can trademark sound. If everybody's heard the ding ding from NBC, they've trademarked that. You can trademark smell, which really doesn't apply online, but sound, sound, logos, slogans, those all apply under trademark. Lastly, you have patent rights. Well, third, you have patent rights. Some things online are patented. How many people here have used Groupon, or at least know what Groupon is? Probably everybody here has. Groupon has a patent for when a deal tips. So Groupon is a perfect example of all 4 types of intellectual property. They have a copyright on their website, the look and feel of their website. They have a trademark on their logo, which is the way Groupon is written out. They have a patent on their tipping process. And then they also probably in the background have trade secrets as to who their customer list is. And trade secrets are things that the general public isn't supposed to know. So you have all 3 of those. Patents are usually any kind of process or physical object. Trademarks are what you're talking about with your logo. And they're each, you get them in different ways. Copyrights you get as soon as you create something. Trademarks, you have a common law trademark, but typically you go through the U.S. Patent and Trademark Office to get a trademark. You go through the U.S. Patent and Trademark Office to get a patent. And trade secrets you get by not revealing them to anybody outside of your organization. So.
Mark?
I may be taking us off course, and if so,
Okay.
don't, just say so.
There's a course, huh? You think we got a course going? Wow, you know more.
That went away like 10 minutes ago, so you're fine.
A week and a half or so ago where I want to say it's a marketing firm down in Texas that's like iCloud marketing, and they're going after Apple over the launch of their iCloud. So whether or not they had iCloud trademarked or copyrighted or what have you, I don't know. I just don't recall. It may have been in the article. So something like that, what happens?
It depends. How many people in here have been to Nissan.com? Has anybody actually gone to Nissan.com? Nissan.com is one of the more famous cases of something similar that you're talking to, where somebody owned it and then somebody else is coming and saying that it's trademark infringement. Nissan.com is owned by, I can't remember his first name, but it's Mr. Nissan. He has Nissan Computers. He got sued by Nissan Motors saying that he's infringing on their trademark. Kind of where this ends up is they have been in court, I think, for like 20 years fighting over this. So with iCloud and with Apple, it could end up being that they just fight for 20 years and you never have any real resolution to it. So it kind of depends on, Apple has a lot of money, iCloud may not, so it might not end up in 20 years of court, but there is a good chance that it could.
It's a lot about enforcement. Yeah, over here.
So, as far as the name being trademarked, what happens when you find that somebody's, if you search your own name, that someone's bought that search term and are using it as a heading on their page, so that when you click on it, it implies you're going to Roper Insurance, and when you get there, it says Roper Insurance, but there's actually nothing to do with us whatsoever.
I can address that as far as the search engine policies. If somebody has a registered trademark, so correct me if I'm wrong, but trademark means I used it first in interstate commerce, right? And I can put a TM after it and not register anything, and it's kind of mine. Then you can take it a step further and register that trademark and make it a registered, and then you put the R. And if I'm using a registered trade name in my, let's say, pay-per-click ads or something, or well, if I'm doing it in pay-per-click ads, Google will turn it off for you. If somebody goes out there and uses your registered name in their ads, they don't allow that any longer.
So you're saying that if they go to ABC Insurance, at the very top it says Roper Insurance. It depends to a certain extent. If they're using it for a deceptive reason, then you can have trademark infringement, and you can also possibly contact ICANN or do it through federal courts to get that taken off. If they're not doing it for a deceptive purpose, if it's something like
Comparison.
Nissan Computers and Nissan Motors, and they really do have, they both have Nissan, or if there was, there's another attorney out there that it's E. Crosby Lewis. He has eclewislaw.com. He's not using that deceptively, trying to take business away from eclewis.com. He's using EC Lewis Law because that really is his name also. So it depends on why and who's using it. If they're really Roper Insurance also, then they might have the rights to it. The other thing you have to look at when you're looking at kind of domain names is where their domain name is or where their website is. If they're outside of the US, then it's going to be harder to enforce your rights if they're in China or in Europe or anywhere else, because then you might have to go to another country to start enforcing your rights.
I just want to beat this to death a little more.
We appreciate that.
You mentioned interstate commerce. That just reminded me of a case recently where I think it was a small company in Colorado, a little restaurant, wanted to go national, do a franchise, and some company in California, this may not be exact, but some company in California had the same name. So they sued them, took them to court. So it turns out that the company in they can't use their name in California, but they can use it anywhere else.
Mm-hmm.
And that happened with Hard Rock Cafe up in
Fraser.
Or not Fraser. It's on the way up. It's in Empire. So that happened with Hard Rock Cafe and Empire. Hard Rock Cafe and Empire, I think, has been there since way before Hard Rock Cafe came here. And you can read online, and there's a lot of different discussion about this. But Hard Rock Cafe and Empire is keeping the name here, and then they got rights. Hard Rock Cafe, the big chain, got rights to use it other places. So that can happen.
Steve?
What about, excuse me. What about when somebody comments on my post on my site? Do I own that post, or?
You're saying you have a blog
So
and they
that
make
my
comments.
blog, somebody comments on my blog. Do I own copyright on that post that they made, or do they retain copyright because they created it?
You're going to love this. This is the answer that every attorney gives. It depends. So it depends on what is on your website. You may have on your website in your terms of use, most larger websites have this. Any websites that I write the terms of use for has this. It has something in the terms of use that states any information or post or emails or anything else that you submit to this website, you give us the rights in full to that information. Kind of like when you submit to, I think CNN has this policy. A lot of big companies have this policy because they want to make sure that if you submit a comment, you submit a blog post, you submit an email, that anything you do, they get rights in and they don't have to worry about paying you for it.
And I just want to make sure, it's not ownership rights, it's usage rights,
Yes.
correct?
Yeah, so you're giving them a license. To actually give ownership rights, you can give ownership rights in a copyright to somebody else. Most of the time when you pay your website developer to develop your website for you, if you've got a really good contract with them, then you are going to get ownership of that website after you've paid them in full and they've developed the website, and they'll do an assignment of copyright that you actually can file with the Copyright Office saying, I own this website. But in regards to when you have a comment on your website, if you have a good terms of use, then you will have ownership of that comment. Well, not ownership, you'll have a licensing right in that comment. Now, in some cases, if you don't have a terms of use, it's kind of up in the air. I mean, they're granting you permission to put it on your website because they left a comment. But they may still own that comment to put on other people's website also.